Welcome to the Republican Professor. I'm my own host, Dr. Lucas J. Mather. Today is Thursday, 6 August, 2026 years after Jesus. And I'm back in the backyard of my common sense epistemology mentor, Dr. Doug Guyvett. Let me give you a little bit of the sound here. There's no wind, so we should have wonderful sound of the waterfall. And I'm having a cigar and a little bit of Woodford Reserve. My shirt is wet because I just got in, and this is a great way to keep cool because it is warm. I would dare say it's hot here in August, and I'm trying to keep cool. But we're back in Baird versus Bonta, trying to finish this thing. VanDyke's wonderful opinion for the court in this open carry affirmation by the Ninth Circuit. And as you know, VanDyke was appointed by our good friend Donald Trump. Isn't that wonderful? Yeah, so he's one of the guys that got on the Ninth Circuit. We're on page 37, letter D. Next, we address the impropriety of conducting a historical analysis. How are you guys doing? You hanging in there? You hanging in there? You want to see a puff of the cigar? Okay, all right, fine. It's an open carry case, and it was brought down in very beginning of the year. I don't know if you recall this, but it was like January 2nd or 3rd or something, affirming open carry in California. Ninth Circuit, dude. And we've gone through most of it. We'll see how far we get today. I got in the pool earlier, and I'm having a rerum novarum. I know somebody's going to axe. It's an All Saints rerum novarum that says Pax et Bonum, which stands for strength and honor. Just kidding. Stands for peace and goodness. And it's not bad. It's a mild Maduro, and I like it. I think I got it for about $4 on Cigar Page. And $4 is really what I don't, anyway. Let's get to Baird versus Bonta. I know not everybody likes cigars. Now, we're in letter D, as I said. D is in boy. JK. B is in dog. It's D as in dog or David. Seriously. Go to noise removal on. Do you want to hear this waterfall? I mean, I kind of like it, but I don't know if you want to hear it. All right. We address the impropriety of conducting a historical analysis predicated on the history that the Constitution left behind. In conducting its historical analysis below, the district court relied in part on a series of egregiously racially discriminatory laws that California offered as analogous examples of restrictions on constitutional carry in the historical tradition. Did you hear that right? Yeah, you heard it right. You heard it right. Pretty scary. KKK stuff that the Democrats are going back to do the same stuff that KKK did back then, which is to disarm black people. You can't make it up. Although the district court professed reservations about leaning on such a sordid legacy, the court ultimately concluded it should take account of the history of discriminatory regulations rather than completely ignore it. Except for they took account of it in order to do the gun control. If the Supreme Court precedent and a faithful examination of our historical tradition required such an account, such a Democrat account, I would say. Remember, this is a Republican saying this. Then courts would be forced to undertake the unpleasant task, but no authority requires that. Indeed, Supreme Court authority counsels against it. Reliance on such racially odious laws in this case is both conceptually suspect and inconsistent with a proper application of Bruin. As an initial matter, it is conceptually suspect because the 14th Amendment was designed to prohibit racially motivated conduct, not countenance extensions of it, whether by analogy or otherwise. And by the way, I'll just say here the 14th Amendment, entirely Republicans, entirely Democrats against it. We're going to scroll down to page 38. It is sad but hardly surprising that racist state legislatures, in some instances, reacted to the 14th Amendment by continuing to engage in and at times even doubling down on racially motivated misconduct. But the fact that recalcitrant groups, largely in the Democrat South, continue to engage in discriminatory misconduct in the wake of the 14th Amendment's adoption does not mean that such misconduct can be read back into the Constitution through interpretation and analogy. It just means that some state legislatures, Democrats, were committed to flouting the 14th Amendment. But even putting aside these deep conceptual problems with relying on such a sordid legacy, Bruin itself instructs us that these kinds of laws are irrelevant to a Second Amendment analysis. In Bruin, remember, that's the Republican decision, 2022, same time that Roe versus Wade was overturned. Remember? Same week, one day before. Remember? In Bruin, the Republicans on the Supreme Court decreed that even when courts are confronting a new technology or a societal problem that did not exist at the founding, when they must use the nuanced approach. The nuanced approach. You guys, let's talk about the nuanced approach. I love the nuanced approach. I think, yeah, so VanDyke, I love the nuanced approach. Let's continue. I don't have a lot of humor today. That's all you're going to get for now. They must be guided by how and why a historical regulation burdened law-abiding citizens' right to armed self-defense. The why of the discriminatory laws I caught my wrapper of my cigar from going in the pool. Sorry. Not that I mind jumping in and going and getting it because the water was bath water today, dude. You guys, the water was bath water today, and not in a bad way, in a good way. It was bath water, guys. Bath water. There was no jolt whatsoever when I jumped in. None. It was like a kind, nice old lady. I don't know. Weird visualization for a pool water, but that's how it felt. Felt like a spa. The why of the discriminatory laws that California and the district court relied upon was unapologetically to disadvantage so-called black people and other historically disfavored by the Democrats groups. That why plainly does not carry over to the laws at issue here, which are ostensibly to deter gun violence and prevent a highly stressful and unsafe environment for everyone. These xenophobic, what's that? I mispronounced it. How do you pronounce it? Xenophobic? No, there's no Z in it. It's an X. And there's no F. No, it's got a PH. Are you looking at this word? And no, it's an X. I studied philosophy. I had to read the pre-Socratics. I had to read Zeno. Starts with a Z. Are you saying that Zeno should have started with an X? Is that what you're saying? Well, I'm aware of that. I took Greek. I know that phobia starts with a phi, but that's one letter. That's two letters, PH. Well, anyway, okay. All right, fine. Xenophobic. Are you happy? These xenophobic, explicitly racist laws are therefore irrelevant to a faithful application of Bruin once again. Don't get too excited. There's only one T on that but once again. Even putting aside the foregoing errors, these 19th century laws present no problem for a Second Amendment analysis unless one is analogizing at exceedingly high levels of generality. We're on page 39 at the top of Baird versus Bonta. The second day of January 2026. VanDyke, dude, did you even take a break during the holidays? Man, you were just itching to get this out. And as we have explained, this is not a nuanced approach, a case where it could even conceivably be permissible to do so. E, letter E. E is in Ernie. I have an uncle named Ernie. Wait. Dwayne, is Dwayne's first name Ernie? I think it is. Well, anyway, his dad's name is Ernie. And it was Ernie's garage where Dwayne works. I think Dwayne has an Ernie in there somewhere. Okay. Aside from that's Austin, Lakewood, Colorado. Shout out to the Austins. Aside from its substantive arguments, California also makes procedural arguments. These too are unpersuasive. Uncle Dwayne put a new mirror on my Acura last time I was out there, with the Acura, which was 2023. Thank you, Dwayne. He paid for it and everything. I mean, he paid for the part and he put it in. Didn't charge me anything. Just did it because he was just doing nice stuff. Thank you, Dwayne. Thank you, Uncle Dwayne. Man, that's really cool. All right. Should we get rid of this waterfall sound? Let's try it. Because I don't know how it is, and so I'm trying to. If it sucks, I don't want the whole thing to suck. Now, first, California argues that Baird is challenging only a licensing regime. Again, that is incorrect. Indeed, as noted above in the operative complaint, Baird abandoned his challenge to particular provisions of the penal code sections which set out California's licensing requirements. The complaint makes clear that Baird is challenging the de jure urban open carry ban. Those I have to laugh. He's challenging. This is what makes the Democrat head explode. He's challenging where they think they're in charge the most, which is what? Which is in cities, right? He's challenging, yeah, you have to let me open carry there where you are. And they're probably like, ah. Those challenges are independent of any challenges to California's licensing requirements in rural counties. Now, we next address the dispute between the parties over whether Baird's as applied challenge to California's urban open carry ban is still alive in this case. Baird has the better of the argument that his as applied challenge is presented for this court's review, but that question is ultimately beside the point. Some cases, no doubt, raise thorny questions about the differences between as applied and facial challenges, but this is not such a case. With respect to California's urban open carry ban, there is no meaningful distinction between the arguments supporting Baird's facial and as applied challenges. And Baird would win regardless of whether his challenge is facial, as applied, or both. First, Baird's as applied challenge to California's ban on open carry in urban areas remains live. The district court stated it dismissed Baird's as applied challenge to California's licensing regime. But as explained, the district court failed to recognize the reality that California's law is an urban open carry ban, not just a mere licensing requirement. And Baird has challenged that ban both facially and as applied to him. The discussion of California's licensing requirements, regardless of its merits, is immaterial to Baird's challenge to California's urban open carry ban. And the district court could not dismiss Baird's as applied challenge to that complete ban by conflating that challenge with any challenge to California's licensing requirement for open carry in rural counties. Contrary to the dissent's assertion, remember this is a 3-judge panel. You got VanDyke and you got, I think it's Lee, both Trump appointees in agreement here. So 2 out of 3 wins. Right? 2 out of 3 wins. Contrary to the dissent's assertion that Baird did not point to any issue with application of California's restriction on open carry, it is clear from looking at the complaint. He's like, just, like look at the complaint. Just, just like read. Just read. that Baird has alleged that he is banned from openly carrying in all the places to which he wishes to travel in California, including those Democrat cities. And he is challenging, as applied to him, those applications of the law that prevent him from doing so, not merely challenging the existence of California's restrictions on open carry. This is so good. While the dissent is correct that as applied challenges often contest how the statute has been interpreted and applied by local officials. See, for example, Calvary Chapel Bible Fellowship versus City of Riverside in 2020. Go Calvary Chapel, man. Standing up for us all during that crazy year. Yeah, we should all just take a moment and thank Calvary Chapel. Thank you, Calvary Chapel. As applied challenges need not hinge on such arguments. In Project Veritas versus Schmidt, an en banc panel of our court found that the plaintiff had raised facial and as applied challenges to the same statute. 2025. En banc, Ninth Circuit. That's 125 in the fourth series of the Federal Reporter, the 125th volume. Starting at 929, look at pages 940 through 941, Ninth Circuit, 2025. There, the as-applied challenge did not hinge on how local officials had interpreted and applied the challenge statute to plaintiff's conduct. We're on page 41 at the top. Instead, the as-applied challenge pertained to plaintiff's proposed conduct, various actions the plaintiff wanted to undertake that were barred by the text of a statute. Sorry, I was adjusting my microphone if you heard any weird noises there. That prohibited unannounced recordings of oral conversations. Baird's as applied challenge here is similar. He has pointed to specific actions he intends to take that are squarely barred by the text of California's statute, and he has argued that California cannot constitutionally prohibit him from taking those actions. The fact that the statute might be applied identically to others engaged in the same conduct that Baird wants to engage in does not invalidate his as applied challenge. In Project Veritas, there was no indication. Okay, hold on a sec. Let me take a look at footnote 20. I'm going to skip footnote 20. I'm looking at footnote 21. Okay, we're going to continue on. There was no indication, page 42 at the top, that the challenge statute would have been applied differently to others acting as the plaintiff there intended to. Yet our court still found that the plaintiff had brought a valid as applied challenge. You guys, all this is about as applied versus facial challenges. By arguing that California's urban open carry ban is unconstitutional as applied to his planned conduct of openly carrying in California's Democrat urban counties, Baird has squarely presented an as-applied challenge to California's urban open carry ban for this court's review. But again, regardless of whether Baird has a facial challenge and as applied challenge or both, our analysis and conclusion would be the same because California's urban open carry ban applies equally to all those it covers. Baird's As applied challenge to the open carry ban boils down to the argument that California cannot constitutionally deny him from carrying openly throughout the state, or at least the 95% of the state by population covered by its urban open carry ban. The analysis of that claim is no different than for Baird's facial challenge, which merely expands the argument to contend that for the same reasons, California cannot constitutionally ban others from carrying openly throughout the state. Bruin's two-step framework applies to both, and both challenges succeed. For Second Amendment challenges, whether facial or as applied, our analysis is guided by the question of whether a challenged law fits within the plain text of the Second Amendment and this nation's historical tradition. Moreover, our approach to Baird's challenge to California's urban open carry ban in this case follows the example of the Supreme Court. The three leading Supreme Court cases interpreting the Second Amendment, Heller, Bruin, and Rahimi, all involve facial challenges to laws restricting Second Amendment rights. Although only Rahimi lays out the test from the United States versus Salerno, that's 1987, the Supreme Court's analysis of the law at issue in Bruin, Heller, Bruin, and Rahimi evaluated the constitutionality of the law on its face, not as applied to the appellant. And Heller, now here's where he goes through the cases, and we're going to take a little puffy, little wuffy, and we're going to listen. We're going to listen to the waterfall. Well, I'm lighting up again. All right. You guys enjoying this? This was done, I started this series in January, that was January 15th, in honor of my first cousin, Dan Mountain Jr. Little Dan, as he was called, my cousin. We were the same age, separated by just a couple weeks. He was just a little bit older than I was. I am. Little Dan, I know you would like this decision. I explained the connection in the first episode, January 15th. You want to check that out? You'll see this in the YouTube playlist on public carry. Second Amendment, public carry. And this is the fourth episode. The last episode was on April 17th. And there was another episode in there. I think it was in maybe February. Let me look really quick. February 19th. So those are all listed. And, you can just search Baird versus Bonta on the website, republicanprofessor.com, for, more, information. It's sunset in Orange County. The sun is going down. I finally get a break from being directly in the sun. I have to put the pool light on in a sec. Like I said, this is not my backyard. It's the backyard of my common sense epistemology mentor, Dr. Doug Guyvet. His pen name is R. Douglas Guyvet. He was my professor for a number of common sense epistemology courses. I also TA'd for him apologetics at the undergrad level, and I did lecture for him in apologetics at the graduate level as well as epistemology at the graduate level. At the same time, I was also the TA of Dr. David Chalky for Intro to Logic, so I was the TA for two professors while I was getting my master's degree in philosophy at Biola. Dr. Dave Chalky came on the podcast. You want to check that episode out as well. Co-hosted with my boy Curtis Olson. Also went through the philosophy program there. I think I don't know if he got his, Curtis, did you get your master's? I forget. I think you did. I know his undergrad was in philosophy. Anyway, not to bring up health food, but let us continue. In Heller, the Supreme Court considered a facial challenge to, I got noise removal on, so you're not going to hear the waterfall anymore. The Supreme Court considered a facial challenge to a Washington, D.C. law banning handgun possession in the home and determined that the law was facially unconstitutional. Yeah. In evaluating the constitutionality of the Democrat Washington, D.C. handgun ban, Heller did not assess whether the law might conceivably have some theoretical constitutional application. Instead, Heller treated the law banning handguns in the home as facially unconstitutional, regardless of whether Washington, D.C. permitted individuals to keep other firearms in the home or whether some set of circumstances existed where Washington, D.C. might be justified in prohibiting some handguns for some people. Incidentally, the guy, Dick Heller, just started following me on Instagram. Yeah. Relying on Heller, Bruen held that Democrat New York, may issue licensing regime was unconstitutional on its face. Bruen set forth the two-step framework, the little two-step we apply in assessing Second Amendment challenges. In applying this framework, Bruen held that a licensing regime that issues carry permits only to applicants who show a special need for self-defense. So just like self-defense is not the special need. So then what could possibly be more special than that? Yeah, this is how the Democrats are thinking. Totally corrupt. Licensing regime that issues carry permits only to applicants who show a special need for self-defense violates the Second Amendment. Yeah. Page 44 at the top. The Supreme Court did not focus on whether New York could lawfully implement its may issue licensing regime in some set of circumstances. Instead, Bruen concluded that the New York may issue licensing regime and similar regimes in 5 other states were unconstitutional. In Rahimi, the Supreme Court assessed a facial challenge to 18 U.S. Code, Section 922, G8, and cited the Salerno test. In analyzing the facial challenge to that statute, Rahimi applied the two-step framework from Bruin, uncoupled from the facts of the challenger's case. Rahimi stated that that statute was lawful as applied to the challenger himself. But Rahimi, that is the case, not the plaintiff, the case, the court in Rahimi. But Rahimi also made clear, that's not the guy, but the decision, that its analysis applied to all applicants of that statute against a person determined by a court to represent a credible threat to the physical safety of another person. Okay. Our own court's precedent is in accord with the Supreme Court's approach in this regard. As indicated in several recent cases, we have applied Bruin's two-step framework when evaluating both facial and as-applied challenges to laws alleged to violate the Second Amendment. In Duncan versus Bonta, for example, we applied, remember, this is the Ninth Circuit. This is a three-judge bench on the Ninth Circuit, VanDyke, Trump appointee, Republican, writing this. Remember, in Duncan versus Bonta, we applied Bruin's two-step framework in assessing a facial challenge to California's ban on large capacity magazines. And then B&L Productions versus Newsom, assess the constitutionality of California's ban on the sale of firearms on state property. Plaintiffs argued that California's law barring the sale of firearms on state property was unconstitutional on its face and as applied to two specific state properties. We're on page 45 at the top. We did not separately analyze the facial and as applied challenges. Now, in Wolford versus Lopez, and by the way, that was just decided by the U.S. Supreme Court, we had the attorney on the podcast, Alan Beck, 2024. You want to check out that episode on billy clubs and knives on the beach in Hawaii. Thank you, Alan Beck, for coming on the podcast. Let's just celebrate that Alan Beck came on the podcast, will you? Let's celebrate with me. Just listen to that waterfall. Thank you, Alan, for all of your hard work and for coming on the podcast. I'm so glad that Dick Heller decided to follow me on Instagram. Wonderful. Love to have him on the podcast at some point. Is it time for the pool light? Not quite. Sun is still technically up. Okay. Quit trying to distract me. Come on. Come on, guys. I'm going to do some reading with the waterfall and the sound in the background. Let's keep going. In Wolford versus Lopez, we considered the plaintiff's facial challenges to California and Hawaii laws that barred firearms in certain classes of geographical locations, such as parks, playgrounds, bars, restaurants, and parking areas. What could possibly go wrong? We applied Bruin's analytical framework in holding that the challenged state law did not facially apply to each geographical place listed. Now, United States versus Duarte addressed a criminal defendant's argument that that statute, which criminalizes the possession of firearms by felons, that's 922G1, 18 U.S. Code, was unconstitutional as applied to non-violent felons like him. That was en banc, Ninth Circuit 2025. We held that that statute was not unconstitutional as applied to non-violent felons, like the defendant. And reaching this conclusion, we applied Bruin's two-step framework. Okay, so in sum, so he's saying even on the cases that we lost, the good guys, the test was the same. That's what he's saying. So in sum, the Bruin analysis, and we're talking about the case we lost at the Ninth Circuit. Now, at Rahimi, we're going to get back to that because I do think we need to get to Thomas's dissent in Rahimi at some point. Why do we need to do that? Because Thomas, God bless his heart, wrote frickin' Bruin, dude. So we'll get back to that at some point. It's a touchy subject right now, but we'll get back to it. In sum, the Bruin analysis conducted for Baird's challenge applies equally to his facial and as applied challenges to California's Democrat urban open carry ban. And even assuming Baird retains only his facial challenge to that ban, it would still succeed. Under the standard for facial challenges, as articulated by this court in Wolford versus Lopez, facial challenges in Second Amendment cases can succeed if plaintiffs show either that the law is unconstitutional in every conceivable application, or that the law seeks to prohibit a broad range of protected conduct that is unconstitutionally overbroad. Because no historical tradition authorizes an open carry ban, and remember, he's saying because no historical tradition authorizes an open carry ban. That's what the Democrats wants to do. That's the gun control. It doesn't authorize the statute for the gun control. Baird's challenge meets the first part of the standard described in Wolford. The only constitutional application California could point to was the availability of rural open carry licenses, a provision distinct from California's urban Democrat open carry ban, and therefore not a constitutional application of the ban. The dissent's assertion, we're on page 46 at the top, the dissent's assertion that California's restriction on open carry are constitutional in some circumstances when California allows concealed carry fares no better. As discussed above, the history indicates that open carry and concealed carry are not fungible. That's a key point. That's a key point. Go back to prior episodes for elaboration on that point. Allowing licensed concealed carry does not automatically authorize an open carry ban. So, in other words, okay, we give licensing for concealed carry, therefore gun control open carry. No, that's what he's saying. No. So California's concealed licensing system does not undermine Baird's facial challenge to the urban open carry ban. That's a key part right there. Are you getting this? You getting the key parts? Some of you guys are looking up fungible right now. You're like, is that some kind of mushroom? If you see the word fungible and you immediately think mushroom, you've been living in California too long. Let's continue. Even if California or the dissent had identified some narrow constitutional application We're doing noise removal on just because if this sucks, I don't want it to suck the whole time. Okay, got noise removal on. No more waterfall sound. Even if California or the dissent had identified some narrow constitutional application of California's open carry ban, which they haven't, our precedent in Wolford makes clear that some facial challenges to overly broad laws can succeed, even if state defendants can identify some small set of hypothetical circumstances where the challenged law would be constitutional. It is difficult to imagine a case where an overbreadth challenge would be more appropriate than here, where California has banned open carry entirely for 95% of the population and throughout 95% of the state by population. The breadth of California's ban criminalizes such a wide swath of protected conduct. Did you hear that? Let's hear that again, because this is the moral issue right here. This is the moral issue. This is the justice issue here. It's about justice, as well as the text and history and tradition of the Second Amendment. This is about right and wrong, guys. It's about justice. It's about morality. Self-defense is paradigmatically innocent conduct. Self-defense against immoral, violent crime. And one of the worst things that a government can do is criminalize innocent conduct. You understand that? One of the worst things that a government can do is criminalize innocent conduct. I'm going to say that a third time. One of the worst things that a government can do is criminalize innocent conduct. And yet that's what the Democrats want to do. They want to do the worst thing a government can do. They want to do the worst kind of thing that the worst governments do and have done. The Soviet Union, the National Socialists during World War II in Germany and before, Communist China, North Korea. Yeah, there's no Turner's Outdoorsmen in North Korea, guys. There's no Gander Mountain in North Korea and Pyongyang. There's no LAX ammo in Havana, Cuba. There's no rifle supply in socialist Venezuela. Are you seeing a pattern here? In the Eastern Bloc countries, there's no gunfighter tactical in Miramar. I'm listing out gun stores in California. There's no gun world, okay, in communist countries, in these National Socialist countries, or even in, quote, the West, quote, the West, like, you know, our friends in Britain that have gone socialist. There's no Greta's guns in London. They're in Simi Valley, by the way. There's no Carol Watson's Orange Coast auctions in Iran, in socialist Iran. Those poor people can't defend themselves against tyranny. They can't. Not to bring up health food, but spinach, continue. Wait, hold on. Tomato, no, that's not it. Lettuce, continue. The breadth of California's ban, what does it do? What's the verb? What's the verb that the Democrats are doing that goes against morality and justice? Criminalizes innocent conduct. It criminalizes such a wide swath of protected conduct. That's what the Klan did. That's what the Democrats did, and they like socialism. You think, oh yeah, the Klan back then was different than the Democrats now. Well, really? How so on this? How so? Same thing. They criminalize innocent conduct. They didn't want people fighting back either against their BS, right? They didn't want people to be able to fight back. They didn't want people to be able to, innocent people to be able to defend themselves against the Klan. Same thing in Iran. It's the same thing in China. Same thing in North Korea. Same thing in Cuba. In socialist Venezuela. In the Eastern Bloc Iron Curtain. And also in so-called Western countries that have gone left. Like, for example, Britain. England. I'm sorry to say. I'm sad to say. The breadth of California's ban criminalizes such a wide swath of protected conduct that Baird's facial challenge was unquestionably meets the second part of the standard described in Wolford. Now, page 47 at the top. This court recently rejected a Second Amendment overbreadth challenge in the United States versus Stenerson as Ninth Circuit 2025. There, the plaintiff facially challenged, among other provisions, that statute, 18 U.S. Code, Section 922, letter N, N as in Nancy, which makes it unlawful for any person who is under indictment for a crime punishable by imprisonment for a term exceeding 1 year to receive any firearm or ammunition. Stenerson argued that the historical record does not support that statute's restriction because it applies to many more offenses than triggered pretrial detention at the founding. All right. So despite agreeing on what constitutes a felony under modern law is much broader than at the founding, this court rejected Stenerson's facial challenges on the ground that that statute is at least constitutional as applied to those indicted for offenses that triggered pre-trial detention at the founding. The statute's application is limited to the small percentage of the population indicted for serious crimes, and any overbreadth concern would apply only to the even smaller percentage of the population indicted for those crimes considered serious today but not considered serious at the founding. I'm going to take a look at this footnote. Okay. More on Wolford, and you can take a look at that, and you probably should take a look at the Supreme Court decision that just came out a couple of months ago. Now, we're on page 48 at the top. On top of that, Section 922, N as in Nancy by its language, applies only for the duration of the indictment. In contrast to Stenerson, California's open carry ban at issue here broadly forecloses almost all Californians' Second Amendment rights to openly carry across almost all of the state and has no time limit. Stenderson's over breadth analysis therefore accords with our conclusion here. Letter F. F is in freak, as in I can't freaking believe what we're dealing with. Noise removal on. In addition to legal arguments, California makes a series of policy arguments in support of its law. For instance, California argues that permitting open carry would create a highly stressful and unsafe environment and has the high potential to create panic and chaos. The district court gestured at this argument as well, explaining that it is significant that there are changed cultural and societal expectations about what is intimidating, frightening, or dangerous that make open carry a particularly frightening manner of carry. None of these policy points can overcome the text of the Second Amendment. Yeah. The Supreme Court's commands in Bruin. Yeah. Or the unbroken history and tradition of allowing open carry in this country. The Supreme Court has already rejected similar policy arguments. Instead, Bruin and Heller prescribed a historical analysis, not policy reasoning, recognizing that policy concerns, that's like a legislative thing, like the problem of handgun violence in this country, cannot trump, yeah, the enshrinement of constitutional rights. California also briefly suggested that changing technology and the dangerousness of modern handguns justify California's departure from the historical tradition of permitting open carry. Even putting aside that policy, arguments such as this can overcome neither the text of the Constitution nor the Supreme Court's commands. This argument, too, has already been rejected by the Supreme Court. If the increasing lethality, we're on page 49 at the top, of modern handguns was a reason to deviate from history and tradition, then Heller would have come out differently. You think? Yeah. The Supreme Court made clear that the dangerousness of modern handguns did not militate in favor of finding an exception to the clear historical tradition of permitting individuals to have a handgun in the home for self-defense. And in any event, this is not a case about new technology. This is a case about a practice, open carry, that indisputably dates back to the earliest days of the Republic. If this is somehow a case about new technology, then every Second Amendment case is a case about new technology. Very well said. Very well said. Okay, we're at Roman numeral VII, and we're on page 49. And we got Roman numeral VIII on page 54. And then we've got Judge Lee's concurrence. And then we've got a bunch of these forms that we can go through later and take a look at what these forms are. And yeah, I think we should probably take a look at these forms. I think it's a bit much today. We've been going for about an hour. So we're going to stop there at page 49, Roman numeral VII. Thanks for joining me on the Republican Professor Podcast. I've been your host, Dr. Lucas J. Mather. Today is 6 August, 2026 years after Jesus. We're in the backyard of my common sense epistemology mentor, Dr. Doug Guyvet. We'd like to thank Dr. Guyvet and his co-author, Holly Pivik, for coming on the podcast back in 2023. Check out their excellent books on the New Apostolic Reformation, including Counterfeit Kingdom and God's Super Apostles, and so on and so forth. Reckless Christianity, I think it's called. And also Doug's other books. He's got one called Evil and the Evidence for God, Temple University Press. He also edited a volume with Brendan Sweetman, Oxford University Press, 1992, called Contemporary Perspectives in Religious Epistemology, which was my text when I took religious epistemology with him. Dr. Doug Guyvet, pen name R. Douglas Guyvet for short, was mentored by the late, great Dr. Dallas Willard of USC, University of Spoiled Children, where Doug got his PhD in philosophy. Dallas Willard was one of a kind, much like Michael Ullman and Harry Jaffa on the politics side for me, con law side for me. The importance of mentoring is very important. That's why I'm doing a series on my grandfather. All the Mr. Steak, James Mather episodes we're doing are honoring his mentoring, not only in my life, but other people, countless other people, as should be evident from those episodes. He mentored Pastor Rob McCoy, who did his funeral last year. Grandpa died at the ripe old age of 102 years young. Rob McCoy was Charlie Kirk's pastor as well, so Grandpa mentored the mentor of Charlie Kirk. God bless you guys. We'll talk to you guys soon. Hang in there. 6 August 2026 years after Jesus. It's a Thursday night.